And welcome back here to Live Now from Fox. I'm Andrew Kraft. Let's move on to more of these top headlines here. Well, this is what we know, that Donald Trump laid the groundwork to try to overturn the 2020 election even before he lost, knowingly pushing false claims of voter fraud and quote unquote resorting to crimes in his failed bid to cling to power. That's according to a newly unsealed court filing from prosecutors that lays out fresh details from the landmark criminal case against the former president here. So we're going to get into some of this. We're going to bring into the conversation to talk about all of this our friend, former federal prosecutor and legal analyst, Neama Rahmani. He joins me. Neama, good to see you here. I just have to point out that we're talking about the 2020 election, 33 days away from the 2024 election. This is still prime of place in so many's minds, including none other than the special counsel, Jack Smith and his team, who has brought this case in the election subversion case in D.C. Judge Tanya Chutkin getting this filing today. It was about 165 pages. And then putting it out there for everyone to see. Parts of it, yes, were redacted. Names of those not charged in this as well here. I guess I got to ask you, Neama, was it just embarrassing for this to be revealed for Donald Trump, or did we glean any new information about what he did both before and after the 2020 election? From my vantage point here, and I've read some of it, a lot of it, yes, salacious, yes, juicy, but not necessarily new.
Not necessarily any smoking guns, Andrew, but what I would say is a lot of what we knew was alleged by Jack Smith in the superseding indictment, and even going back to the January 6th committee, we're seeing some of that evidence come through from what I call private actors, right? Family members of the president, some of whom were, of course, White House staff, but private lawyers and importantly, campaign officials. So, not necessarily any new smoking gun type evidence, but the sources of the evidence matter because we know, because of the Supreme Court's very broad presidential immunity opinion, nothing that relates to official acts that can't come in. So, all the allegations related to the Department of Justice and folks that were arguably acting in an official capacity. That's all out. So we have a new set of evidence that comes in, but essentially the prosecution's theories are the same. Like you said, Andrew, that Trump was going to declare victory no matter what, that he was told that the mail in ballots would favor Democrats, and that some of this litigation was arguably frivolous because Donald Trump was told that. So not necessarily anything new, but the sources of the evidence do matter.
Okay, so Neama, this was included in the filing, quote, the details don't matter. Trump said that when told by an advisor that a lawyer who was mounting his legal challenges would not be able to prove the false allegations in court. That's according to the filing just today. In another private lunch, days after the election, Vice President at the time, Mike Pence, urged Trump to accept the results of the election and run again in 2024. Trump replied, quote, I don't know. 2024 is so far off. Also, Trump said this, so what? As he was listening to an aide who alerted Trump that Vice President Mike Pence at the time was being evacuated from the Capitol on January the 6th here. So yes, there are some damning moments included in the filing, but this was all because Jack Smith had to rejigger this indictment in order now to fit the Supreme Court immunity ruling standard. Isn't that right? That's what we're seeing here. This isn't necessarily a new set of charges. The superseding indictment was filed about a month ago here. This is just to lay out and back up that. Do I have that right?
That's absolutely right. And depending on what side you're on, Jack Smith is either tailoring the evidence to the Supreme Court's opinion or trying to pigeonhole it through. And, a lot of what you talked about in terms of the evidence is important if indeed there's a criminal prosecution. And we all know that if Donald Trump wins a month from now, this is all going to go away. But assuming for the sake of argument that Kamala Harris wins and this prosecution continues, that intent matters. We need to show what Donald Trump knew and how he acted. So what he said and what was said to him is important if there is indeed going to be a criminal trial here. So, talking about that private lawyer that was pursuing the litigation, Donald Trump said that he wouldn't be paid if he was unsuccessful, and the staffer said that allegedly that that person would never be paid.
Mm.
That's arguably evidence that Donald Trump knew the litigation was going to be unsuccessful. There's some communications with some staffers, right? One of them, again, not Trump himself, but the staffers saying, make them riot, or said that litigation should be pursued even if it's expletive. And I don't want to say the expletive, but what Mike Pence, Bill Barr, all of these individuals in Trump's inner circles, what they told the former president is important if you are trying to establish that knowledge and intent for a criminal prosecution.
Okay, let's talk about knowledge and intent here, because it seems to me the ball is now in Judge Tanya Chutkan's court, no pun intended, to determine whether or not anything that Jack Smith in this filing and his team has laid out falls under private acts, even though Trump, while saying and doing all this, is still president. And so that is the tricky standard that now the Supreme Court has thrown back to the district court judge, Tanya Chutkan. So we'll have to wait and see whether or not this fits that new bar, that new standard. But getting back, though, to Trump's state of mind, won't Jack Smith, Neama, have to prove Donald Trump knew that he lost while saying all of this in the meanwhile? That is, I mean, how impossible is that? I mean, is that Jack Smith's task right now? That, yes, he has a lot of these examples that have been corroborated by witnesses around Trump in his orbit at the time, before and after the election. But does he specifically have to prove that Donald Trump, while pursuing all this, knew he had lost? Jack Smith, in his superseding indictment, already says Trump knew he lost. So is that it, or does Judge Tanya Chutkan need more?
Well, he needs to prove it if he's going to actually get to a jury. So this is obviously step one, trying to clear the legal hurdle of presidential immunity. So the standard is, if you take all this evidence and you construe it in the light most favorable to the party who isn't moving for dismissal, can this potentially prove beyond a reasonable doubt that Donald Trump committed election fraud and there was no presidential immunity? So that's what Jack Smith's trying to do. So obviously a very different standard when you're trying to convince 12 out of 12 jurors in Washington, D.C. that Donald Trump knew he lost the election and intended to overturn the results anyway. That's not what Judge Chutkan is going to be doing. She's going to say, is there enough evidence to even get to a jury? Because if we're talking about official acts, that's absolutely immune. Even anything on the periphery is subject to immunity. The Supreme Court's decision was very broad. So we're going to clear that first hurdle first, maybe back to the D.C. Circuit Court of Appeals, definitely, and maybe even go back to the Supreme Court on this issue now that these new facts have been laid out in this filing.
Okay, so I want to just pose to you a thought experiment here. I think that was first proposed by legal scholar Andy McCarthy. Essentially saying that, if Jack Smith is alleging that Donald Trump is not acting in his official executive capacity, and you have the testimony, we know Vice President Mike Pence sat before a grand jury as a witness, that a lot of that is included in this. Wasn't Mike Pence, though, acting in his official capacity as vice president, doing all this? So how can Trump doing this be not acting in his official capacity, but Vice President Mike Pence can be, as the president of the Senate, acting in his official capacity here when denying Trump's overtures for Pence to decertify, so to speak, the electoral college votes in these states where Trump thought it was in question? Does that make sense?
So it does make sense, and this is the sort of nuanced constitutional issue, and it's really and it's really anticipating what Trump's lawyers are going to argue. They're going to argue that Trump was acting in his official capacity as the chief enforcer of our nation's laws. He was investigating election fraud. Now, what Smith is arguing, and again, he's looking at the Court of Appeal, is that it's not the duty of the executive branch to determine who's president. It's a function of Congress, right? That certification. So it's a separation of powers issue. What they're trying to do, if you're the prosecution here, is to separate Donald Trump from any official activities. Now, obviously, the vice president is uniquely situated because not only is he a member of the executive branch, he's also cast the tie-breaking vote in the Senate and a member of the legislative and Congress as well. So you have this dual role, and that's why you constantly see the prosecution arguing that Mike Pence was Donald Trump's running mate, because of course we know that campaigning has historically been held to be personal. So there's a lot going on, especially with respect to Mike Pence, because he has multiple roles in all this.
So, Neema, I'm seeing a lot of critics of Jack Smith and this action today. Obviously, Tanya Chutkin permitted this redacted version, this filing, to be made public today. That's why we're talking about it here. But some critics of this action, supporters of the former president, are saying that Jack Smith and the judge are violating a DOJ policy when it comes to elections, that you don't make any moves 60 days out before a presidential election when something, legally speaking, includes a candidate here. Is that at play or no? Is that far-fetched? Is that a leap to make that criticism or not?
It's a fair criticism. It's not squarely on point. So for those of
Okay.
folks who are watching, the DOJ doesn't have an internal 60-day rule that says generally you're not supposed to announce charges or file 60 days before an election, because you don't want your filing to influence an election. Now, obviously, this is a filing that originally happened much earlier. The superseding indictment was before this. So it technically doesn't violate the four corners of the 60-day rule. Maybe it violates the spirit of it. Unfortunately, it does seem that our criminal justice system has been so politicized, and I don't know if, based on Judge Tanya Chutkin's timeline, they could have filed this afterwards. But one thing I do want to say, Andrew, is I'm a big believer in transparency in public filings. I don't like it when the government tries to hide things, or the defense. We have open courts in our country for a reason. So I do believe that the unredacted filing, if it was timely, was appropriate here.
All right, Neema, just lastly, where does the case stand? I mean, this has been a year in the making now. It's been through so many hoops and hurdles, back and forth here. Who has the upper hand, Trump and his team of attorneys, or Jack Smith here? You already noted that, if Trump wins the presidency, wins the election, this isn't going anywhere. But say he doesn't. Does Jack Smith have the upper hand? Will Jack Smith see this to its completion here?
There's no question in my mind, Andrew, that Donald Trump has the upper hand for many reasons.
Oh.
One, that there's a political path to victory. Two, there's the legal path to victory through the appellate courts. It's possible that Judge Chutkin or the Court of Appeals or the Supreme Court tosses this case entirely on immunity, or maybe even Jack Smith's appointment himself. We know that Judge Cannon did that there in South Florida. And of course, even if we clear those two very important hurdles to convince 12 out of 12 jurors, even in a heavily Democratic city like Washington, D.C., that Trump intended to commit election fraud unanimously, that is no easy task, and what will certainly be the most politicized trial in American history. So I do believe Donald Trump has many paths to victory, and Jack Smith has to clear all those, which will be no easy task.
But Neema, we are getting a better sense, though, in this filing of Smith's strategy going forward. And you kind of intimated he is somewhat undeterred in that. But you said there's no smoking gun. So can we kind of grasp where Smith is going with this?
Ideally, if you want to prosecute someone, you want an admission, and Donald Trump arguably genuinely believed that he won the election. I think that's a fair argument. Now, maybe that belief was unreasonable, and I think a lot of folks would certainly put it that it was absolutely wrong. But if Donald Trump genuinely believed that he won, did he really commit election fraud? Probably not. That's why you see Jack Smith focus on the timeline, that he was going to announce his victory no matter what. And individuals allegedly told him that those mail-in ballots would come in and they would support President Biden. So that's why there's so much of that. But I think there's just a good defense here for Donald Trump and why he may actually win this in the unlikely event we actually get all the way to a jury trial.
Oh, wow. So Jack Smith's long slog continues. Neama Rahmani, thanks so much.
Thanks for having me, Andrew.